So this presentation overlooks the case of Charles Kveragas versus Scottish Inns Inc. And the case made it to the U.S. Court of Appeals in February 15th in 1984. This presentation will be conducted by Eddie Babajanov and Taylor Cloud. On February 16th, 1982, the Kveragas family were occupants in the Scottish Inns Motel in Tennessee. Their room was equipped with a hollow core door, and that door fit poorly into the door frame. The door had also lacked a deadbolt locks, which are considered industry standard, but it did have a security chain attached, and it had a grade 3 lock in the handle. While the door was locked and secured with the chain, at 10 p.m., three intruders were able to kick the door down, and hotel room was then invaded. The husband, Charles, was shot, and the wife, Esther, was injured. The intruders took about $3,000 from the victims, and the Kveragas family, they filed for a diversity action against the owners of the hotel, and they claimed that the injuries resulted as as a result of negligence from the hotel owners to provide safety for their guests. The district court ruled in favor of the hotel operators, stating that, quote, the defendants had no duty to protect the guests, and that the sudden criminal acts of the assailants were the sole proximate cause of plaintiffs' injuries, end quote. Based on the decision of the Supreme Court case Kornprost versus Sloan, which involved a woman who was assaulted in a shopping center parking lot. That case had decided that there is no duty upon the owners of the shopping center whose mode of operation of their premises does not attract or provide a climate for crime to guard against the criminal acts of a third party. On the other hand, defendants stated that plaintiffs didn't show enough evidence that the owners were directly negligent or knew that these acts were happening, which posed a quote-unquote imminent probability of harm to the guests, attempting to clear them of any wrongdoings or intentions. Lastly, the case was appealed by the Kveragas family and escalated to the U.S. Court of Appeals. So some of the questions that need to be addressed here begin with, number one, were the necessary steps taken to evaluate the probability of danger? And secondly, does this case constitute negligence on behalf of the hotel owners and operators, i.e. was the property made more secure by reinforcing access points? And then lastly, did the innkeepers have an obligation to protect guests from wrongful actions of third parties? So there's a couple of rules here that apply for this case, beginning with the duty of due care, and this is a standard that applies specifically to innkeepers to protect their guests and to take the necessary measures to make sure that their guests are protected. Second rule that applies would be general premise liability, and that just basically refers to the fact that owners must take responsible account of any danger or possible danger, and produce the necessary precautions based on the probability. For example, if you're owning property or a hotel in a high-risk area, it's definitely something that would apply. Thirdly, negligence would be one of the primary rules in this case, because hotel owners specifically have a responsibility to protect their tenants and the tenants' property that they keep on site by taking the necessary precautionary measures to prevent possible injury or for guests' property being compromised. And lastly, there is the rule of proximate cause. And proximate cause is actually what binds the hotel owners to, the actual third party responsibility. And what I mean by that is that hotel owners would be liable for any misconduct of third parties only if it's proven that they were in fact negligent. Um, and this is something that is standard under the rule of proximate cause.
The court stated that the district court had cited Cornpro's case improperly, claiming that there is a special relationship between an innkeeper and a hotel guest, which is different than the relationship between a store owner and a shopper in a parking lot. Historically, under common law during the medieval era, innkeepers had a high level of liability. More recently, the common law has responded to different cultural changes by lessening the innkeeper's liability for criminal acts committed by third parties, but not totally eliminating the responsibility. The court acknowledges that there are different expectations of security when entering a hotel room as opposed to entering a shopping mall or a parking lot. Also, inn operators are often better able to protect guests from the wrongful acts of third parties. In this case, the court cited the case Zhang versus Leonard, where the defendant Zhang was shot by a robber in the parking lot of a motel. The motel was ultimately found to be negligent in failing to provide for his safety in their parking lot. Under the Zhang rule, the first responsibility of the fact finder is to determine what, if any, protective measures would have been employed by any reasonably prudent motel operator under the same circumstances, which the fact finder finds existed at the time of the injury. Also, the fact finder next should determine whether the actions of the responsible defendants conform to the actions of a reasonably prudent motel operator as found by the fact finder. As we learned from earlier in the quarter, under tort law, duty of care considers the degree of carefulness that a reasonable person would exercise in a given situation. In this specific case, appropriate measures must be taken to ensure the safety of hotel guests, so any negligence can be treated as a breach of the duty of care provision. Additionally, the second restatement of tort says, a landowner who uses the land for business purposes with the public is subject to liability to members of the public while they are on that land. This liability extends to physical harm caused by the accidental, negligent, or intentionally harmful acts of third parties, and by the failure of the possessor to exercise reasonable care to, number one, discover that such acts are being done or are likely to be done, or number two, give a warning adequate to allow the visitors to avoid the harm or protect themselves against it. So the duty placed on innkeepers to protect registered guests from the misconduct of third parties is a duty of care under all the circumstances. So looking into a little bit more on the causation factor, before liability attaches, even if negligence is found, plaintiffs must establish causation, the third element of a negligent action. Motel operators would be considered liable for the misconduct of third parties only when negligence of the operator is considered to be a proximate cause of the injury sustained. The ultimate causation question is whether the injured party would have suffered the same injury if the motel operator had employed some protective measures, which the fact finder determines should have been employed in the exercise of reasonable diligence. On the other hand, if the fact finder determines that the guest's injuries would not have occurred or would have been less severe if reasonable protective measures had been employed, then the failure to employ these measures is considered the cause of these injuries. The plaintiff would bear the burden of persuasion relating to causation issues. So in conclusion, based on evidence about the door lock, industry standards, and given the fact that the door was kicked down, the court found it sufficient to permit a jury to find that a reasonable motel operator would have employed a more substantial door and lock. The responsible defendants failed to adopt these protective measures, and that the protective measures had, if the protective measures had been adopted, the assailants would not have been able to gain entry into the hotel room. The motel is located and owned by defendant Sue Chi Sue and is leased to the Sue Enterprises Incorporated, which operate the motel as a franchise of the defendant Scottish Inns Inc. This brings up a little wrench in the story as it addresses the question of who is actually liable, and it's an added complication that was not addressed in the original district court hearing. So, because of this, the judgment of the district court was reversed and the cause was remanded for a new trial. And that is our case. Thank you for listening.